Mike's just on mute there.
Can you hear me now?
Yeah, that's fine. Loud and clear. You're looking very smart.
Ah, thanks.
I put this on this morning, and I suddenly realised I was going to be talking to an audience of Irishmen. So
Yeah.
I'm not sure if it's entirely appropriate. So I'll try and
Yeah. Put the camera up higher.
So yeah, okay. So
I'm just wondering about the sharing the PowerPoint. Is there a way that I can split the screen? Can you do that? Enable the share screen.
Yeah.
From your end there.
Yeah. So I've just you should be able to share your screen now.
Advanced. Yeah, it just seems to be a kind of either share it all or nothing.
What were you hoping to do?
Well, maybe we'll just share the kind of, if I could, like, what do you see there on your screen now?
I can see your. Sorry, I'm just slightly distracted. My daughter has only just passed her driving test.
Oh,
She's reversing off the drive and seems to be perilously close to a car that's on the road. But that's good. She's remembered how to straighten up now. Sorry. So I can see your slide, but it's not in full screen mode.
am I on the screen now?
I can see you as a thumbnail to my right hand side, but to be fair, people can change what they see. Obviously, they can't change what you're sharing.
Yeah,
but they can see. I can see you okay, but people can change the view that they see and how they see it.
Okay, so will I do it the way I have it now? Is that probably the best?
It looks fine to me. Yeah. So, and then if you use that little icon to make each slide fill the screen, you know the one I mean, down bottom right hand side. Yeah, perfect.
Okay.
So now what I can see your first slide, but I also got a preview of your second slide.
Ah, very good. I thought it was a kind of all or nothing, that once the slide is shared, that basically all you hear then is my voice.
No, we definitely still see you. Whether you want to show the next slide in preview or not, I don't know. That's up to you, really.
Yeah. So then has that moved to the next? Yes.
So now I've got your introduction is in my main screen. Now we're back to the
opening
title screen, but I can also see your next slide in miniature on the right hand side of my screen as I look at it.
Is it okay to have the next slide in it?
It's up to you. I personally, I think it's slightly distracting because it means.
Yeah, I'm just wondering how do I get rid of that? I'm not sure how to remove that. So what are you seeing now?
So now we're now back to, I can see your toolbar,
yeah,
and all the gubbins. I mean, I should be basically seeing what you're seeing, because at the end of the day, it's just sharing your screen.
Okay, I can't seem to get it back to the. So I'm just going to stop sharing and I'll try it again.
Okay.
I can't seem to get it into that mode again for some reason.
So if you go if you go down to the bottom right,
Yeah.
yeah, that one will start the slideshow.
Doesn't seem to be though. Maybe I'll just X out of it and go back into it. Yes, I'll do the share screen. And then bottom right. Okay, so that's back working again, but again, the preview slide is on it.
If you go down to the left-hand side,
Yeah,
next icon along, that one there, what does that do?
it kind of shows all of them as a thumbnail.
Okay. What about what's that one do? So more slides. Let's try that one.
Hide presenter view.
Yeah, try that. Try
Yeah.
high presenter view. Oh, now,
No, I'm not sure what happened there.
all right. Well,
Yeah,
let's.
I'll just go back into it.
Yeah.
I think it's fine.
I've got a few people in the waiting room, but not many yet. So,
Okay.
but as we talked about the other day, I won't open it up until the dot of 4 o'clock anyway, and then we'll just still leave it open for.
Yeah. Do you want me to hold off on sharing the screen for now?
Yeah, if you don't mind. Yeah, just.
Okay.
That's it. Brilliant.
So do you have events around the UK and in Ireland?
Yeah, very much so. I mean, Ireland was the pioneer for Foil, at least, of online events, because we started Foil Ireland in 2019, so it was just pre-pandemic. But what we realised was that if we were going to engage with the entirety of our membership, which is dotted around Ireland, in Cork and Limerick as well as Dublin, we needed to get these events out to them. So we were already streaming face-to-face events out to other parts of the country long before the pandemic started. So when the pandemic hit, we were kind of already geared up to go. So it was great. But we're just getting back to doing face-to-face stuff here and there, but it's never going to go back to as many face-to-face. Online has really got a place.
Definitely.
It's not perfect, but it suits an awful lot of purposes.
Very efficient.
Absolutely, and not to put too fine a point on it, it's very cheap.
Yeah.
I mean, when we were putting on face-to-face events in Dublin, it was, we didn't get any change out of about £5,000 in terms of euros.
Yeah.
Whereas we can reach an audience of, I guess there's probably about 40 or 50 people, basically for nothing.
Yeah.
So it's good. Right, I've got a few people in, so
Okay.
I think that is 4 o'clock. So I'll just bring them in, but we won't start. I'll just say, we won't start just yet. And I'll keep an eye on the waiting room and manage that as we go on. Afternoon, everybody. We're just going to wait a couple more minutes before we start, just to give people time to join and dial up. I'm actually particularly waiting for Rachel Turner because she agreed to introduce you, Ed. So
But she was in touch earlier, so I think she will be online.
yeah, I can't see her, unfortunately. It doesn't appear to have dialed in so far, but we'll give it another minute or two. There she comes.
Maybe later. Okay. I think Rachel is there, but I think microphone might be on mute. Oh, it's
Yes, it bathed in an angelic glow there, Rachel.
Are we waiting for a few more people to dial in, or
Yeah,
will we
people,
start? Okay.
yeah, people are still coming in, but
Okay, perfect. I
I
had
mean,
some
that's,
difficulties there getting in.
did you? So I mean that is 3 minutes past. So if I could just very briefly just go through a couple of housekeeping points on it, Rachel, and then I'll pass over to you to do the introduction. So welcome everybody. I've lost count of how many online events we've done for Foyle Island, but this is the first one this year, I think. So welcome everybody. Lots of people still joining actually, so I'll just keep letting them in. Just a couple of housekeeping things, really. So, firstly, apologies for the shirt. I had forgotten that I was talking to an audience in Ireland this afternoon, and casually put on my patriotic England rugby top. So, apologies for that. I'm sure you're going to beat us anyway. So just to say the meeting is recorded, but please don't let that put you off asking any questions. The recording is really primarily for the purposes of producing a write-up of the event for anybody who's not been able to join us this afternoon. So please don't let that put you off. You can ask questions at the end verbally, or if you want to put something in the chat room at any time, please feel free to do that. So I think that's all I need to say, really. If you're able to, I think it's nice if you can keep your camera on, so that Rachel and Ed are not sort of kind of talking to blank screens. It can be a little bit off-putting, but it's entirely up to you, of course, and we don't insist on it. Okay, I think that's enough from me. So can I pass over to you, Rachel, please?
Of course. So good afternoon, everyone. Today we're delighted to have Edward Murray speaking to us in relation to strikeout applications. And I'm sure a lot of you on the call already know Edward, but for those of you that don't, just by way of introduction, Edward is a practicing barrister in the Law Library and has a particular focus on commercial, chancery and banking matters, to name but a few. He has also recently co-written an article in the Commercial Law Practitioner Journal, which some of you may have already seen, and it's in relation to today's topic of strikeout applications. So I know it's a topic of interest to most practitioners and in particular to our clients. So Edward has kindly agreed to bring us all up to speed on the topic and recent developments. So I'm going to hand you over to Edward now. Thanks, everyone.
Thank you very much, Rachel, and thank you very much, Lawrence, for having me. As Rachel has said, I'm going to speak about the practice and procedures of striking out proceedings and what that entails in litigation. I think it's fair to say that it's a type of application that would be of interest across the spectrum of cases, whether it's commercial, financial, insurance related cases, personal injuries, because I think it's fair to say that no defendant really wants to be in litigation for a long time. And if proceedings can be dealt with expediently without the need for a full trial, I think that definitely is within the interest of a defendant. But it's also a matter where plaintiffs need to be conscious of, because when they issue proceedings, they need to be wary that it is possible for a defendant to have the proceedings dismissed for various reasons. And with that, for the plaintiff, that would bring with it cost implications, etc. So in terms of the procedure on how to get proceedings struck out, there are two primary routes. That's within the rules of the court and then within the inherent jurisdiction of the court. So the particular rule that you're looking to in the rules of the superior courts is Order 19, Rule 28. And that is accompanied by an inherent jurisdiction of the court to have proceedings struck out. And that flows from the High Court's full and original jurisdiction. And with that also flows a general power for the court to control its own procedures. I'm sorry, I should put this into display mode. I think that should be the correct mode. So Order 19, Rule 28 provides that the court may order any pleading to be struck. Sorry, I think.
Edward, I think you're on mute. Edward, I think I can hear you now. Yep.
Is the camera working? I think there was an error on the Zoom.
Camera is working and we can hear you.
Very good, very good. Okay, I'll leave it in that mode. So as I was saying, Order 19, Rule 28 provides that the court may order any pleading to be struck out on the ground that it discloses no reasonable cause of action or answer, and in any such case, or in case of the action or defence being shown by the pleading to be frivolous or vexatious, the court may order that the action to be stayed or dismissed, or judgment be entered accordingly, as may be just. So essentially what you're looking at is that the court has the power to strike out pleadings, firstly, where they disclose no reasonable cause of action, and secondly, the key words being frivolous and vexatious. So if the pleadings provide for claims that are frivolous or vexatious, that allows the court to trigger the jurisdiction to strike out the pleadings.
Did you want to show those slides, Ed?
Yes. I on my screen it is displaying, but an error came up on my screen.
Okay. Do you want to try share screen again?
Yes, I'll try that again. That's hopefully that is that showing on your screen now, Lawrence?
That's brilliant. Now I can see one slide on the whole screen, and just with your image on the right hand side. So I think this is what we were trying to achieve earlier, actually. So this looks great.
Very good. So pleading, in terms of pleading for the purpose of Order 19, Rule 28, it refers to the entire pleading. So whether that's the statement of claim or the defense, it's the entire case essentially. And that specific rule allows for the entire proceedings to be struck out. And that's to be contrasted with Order 19, Rule 27, the preceding rule, which provides for the strikeout of particular portions of a claim. So for example, with Order 19, Rule 28, whilst you're striking out the entire proceedings, with Order 19, Rule 27, you can strike out various allegations, particular allegations, or let's say in a claim that provides for negligence and breach of contract. Order 19, Rule 27 allows for the court to strike out just those specific or individual claims within the entire proceedings. And a key feature of Order 19, Rule 28 as identified by Chief Justice O'Higgins in McCabe versus Harding of 1984, it was emphasized that in order for the rule to apply, vexation or frivolity must appear from the pleadings alone. So when the rule is triggered, sorry. Oh, so when the rule is in operation, the court is not permitted to look behind the pleadings. The wording of the pleadings is all that the court can look to. And on the face of the pleadings, the case must disclose no valid action. So for example, the court under the rule is not allowed to look at the evidence. It's purely based on the pleadings and on the particulars. So you'll often see if a defendant is faced with a statement of claim, in order to determine if it is a claim worthy of striking out at the outset in early course, a defendant will usually issue a notice for particulars to allow the plaintiff a further opportunity to particularize their claim. And if the plaintiff returns back with replies to particulars that again don't disclose a cause of action, a defendant, it is open for a defendant to issue an application to strike out the proceedings. That Order 19 Rule 28 is to be contrasted with the inherent jurisdiction of the court. So the court, as I said, has full and original jurisdiction, so it has control over its own procedures. And as identified in Barry versus Buckley, Supreme Court of 1981, it was identified that the court has the power to strike out or stay proceedings that were frivolous, vexatious, or bound to fail. But unlike the rule, there's flexibility and there is a discretion of the court, and the discretion extends to looking at the evidence. So as part of a motion, the defendant can bring to the court's attention evidence on affidavit which would show that there is no basis for a plaintiff's claim such that it ought to be struck out. And you can probably tell that type of application would be, it's fair to say, might be easier in summary type proceedings where the evidence is based on documentary evidence or documents. For example, commercial cases based on loan facilities and mortgages. Because of the paper trail, arguably, it could be easier to bring an application under the inherent jurisdiction to have a claim struck out as against a claim where a plaintiff could argue a claim that's related to an unliquidated sum or a tort, for example, where a plaintiff would have to be given the benefit of the doubt that there may be evidence that would validate their claim. But again, the key difference between the inherent jurisdiction and the rule of the court is essentially that the court is allowed to look at the affidavit evidence and determine if a claim is frivolous or vexatious. And I've set that out in the next slide. The difference between them was identified in the Barry versus Buckley case. Affidavit evidence is not to be engaged in the Order 19 Rule 28 method of bringing the application. And you will see, it is very common for applications to the court to be brought under both jurisdictions. So a notice of motion 9 times out of 10 will bring an application to strike out the plaintiff's claim under Order 19 Rule 28, and at the same time the inherent jurisdiction of the court. So if one fails, the other might succeed, and vice versa. And you'll see that the difference was outlined most recently in the case of Toy versus Toy, decision of Mr. Justice Dignam, where he says that under the inherent jurisdiction, the court can, to a very limited extent, consider whether there is a credible basis for suggesting that the facts as asserted are true. And if not, then the proceedings may be struck out on the basis that they are bound to fail on the merits. And again, it's very limited the extent to which the evidence can be engaged with. And that follows on to the next question of why is the court limited by the extent to which it can engage with the evidence? And that has its basis in the constitutional rights of every party in the land, essentially a right of access to justice. And because of that right of access to justice, there needs to be a balancing act between, on the one hand, the right of the plaintiff to have his or her day in court, as against the rights of the defendant to be allowed not to engage in a frivolous claim which carries with it cost burdens, time, effort, etc. So again, the court engages in a balancing act and will determine whose rights should prevail based on the case being brought by the plaintiff. Again, that ties in with the logic that there needs to be a high threshold for a defendant to succeed in having a case struck out. Justice Clark in Keohane versus Hines 2014 Supreme Court decision stated that the jurisdiction is to be sparingly exercised and only adopted when it is clear that the proceedings are bound to fail, rather than where the plaintiff's case is very weak or where it is sought to have an early determination on some point of fact or law. So it's clear that if you're a defendant bringing the application, you do need to bear in mind that there is a high threshold. So I think you really have to engage in an analysis of the claim being brought by the plaintiff to make sure that you can reach the threshold in having them struck out. Noting the various cases, key cases, a sort of general categorization of type of sort of a category which may allow the court to strike out a claim has emerged. I've noticed 4 key kind of areas. One is where there's no statutory or legal basis for the plaintiff's claim. So on a legal basis, if the claim at the outset has no footing legally, well then I think that the defendant can consider bringing an application to strike out. A second key category would be the doctrine of res judicata, which prohibits rather a plaintiff from bringing a claim that has already been determined by the court. So essentially bringing the exact same claim twice, which has been determined by the courts on its merits, that's not permitted. So if a plaintiff attempts to do that, a defendant is within their rights to bring an application to strike out the proceedings. A third category, if a case is clearly statute barred, that might allow a defendant to consider bringing an application to strike out. A defendant should bear in mind, however, that the statute of limitations is usually a point of defense. So the court could take the view that it may be premature to bring an application to strike out on the grounds of statute of limitations until such time as the proceedings reach the stage of filing a defense where a claim of statute barred is included in the defense. And then a fourth category ties in with the frivolous and vexatious key terms, that fourth category being where the claim is futile, misconceived, hopeless, or irremediable. So just looking at the first category, where there's no legal basis for a claim, a recent example of that is O'Donoghue versus AIB Mortgage Bank, and another that is from 2017. And that was a case where the plaintiff sought an injunction as against the defendants in circumstances where the plaintiff was taking issue with AIB as a state, the state having an interest in the bank, selling off its shares. And the plaintiff was aggrieved by that, was purporting to make a claim that that was essentially unlawful and wrongful. However, the court took the view that it was not a valid claim. It didn't have the jurisdiction to engage with the case. And that stems back to the separation of powers. The court stated that it is simply not open to this court to entertain a case such as is before the court that requires this court to decide upon matters of political economy. There is no legal competence for this court, but also no practical expertise to make a judgment on such matters. Again, the case was trammeling on the separation of powers and verging into areas that were more amenable for resolution by the government. The court noted 5 key points to bear in mind when bringing an application to strike out. Now, I should say the defendant was successful in striking out that claim because the court had no power to deal with it. But the court noted 5 key points. Firstly, that the plaintiff's claim has to be taken at its high watermark. So you have to, the court has to accept the plaintiff's pleadings and case at its height. So is it possible that the plaintiff's claim at its height will succeed? And if that is true, well, then the court is extremely unlikely to strike out the proceedings. In fact, it can't. A second point of note, that the burden of proof lies in the defendant. So when you're bringing the application, you have to make sure your proofs are in order. And obviously the burden of proof on the balance of probabilities is on you. Third point, that the court can exercise a jurisdiction to strike out a claim on the basis that on admitted facts it cannot succeed. Again, that ties in with the high threshold. Fourth point, that the courts must determine whether any points of law raised can be so clearly and readily resolved in favour of the defendant that to allow the action to proceed would constitute an abusive process of the court. And fifthly, that legal issues that are sufficiently substantial as to fall outside that bracket should be left to the trial of the action in the proceedings. So again, you can see there is a reluctance to strike out the proceedings. There is a high threshold, so beware of that. Another example of there being no statutory or legal basis for a claim was in Danske Bank versus Scanlon of 2016. That was a sort of a banking finance law type claim, and there is a long line of cases which make similar allegations. So the plaintiff here was making allegations of reckless lending, so essentially a claim that the banks shouldn't have loaned money to the borrower, and on a macro global level, that the banks in around the time of the financial crash were being reckless, such that it was the bank's fault and not the borrower's. Other claims in that case included that the bank was in contravention of the Consumer Protection Code, that they engage in excessive securitization, creating a false boom economy, that the bank's license was invalid, that the bank failed to provide lawful paperwork, that the receiver aggressively pursued a quick sale of the property at issue, that the receiver removed the rent roll, therefore removing all available income from the property. So, having considered all of the various claims made by the plaintiff in that, the court granted the defendant relief and struck out the proceedings. And in the decision, Judge Fulham stated that the courts afford litigants in person an appropriate degree of latitude. However, they're still bound by the laws of evidence and procedure. And the plaintiff's extensive blanket grounds amount to general assertions that are not backed up by evidence. It is the court's view that the plaintiff's claim discloses no reasonable cause of action. It's bound to fail. Accordingly, the plaintiff's claim as against the bank and the receiver is struck out. And you'll see that the court clearly engaged to some degree in the evidence. And so that was the inherent jurisdiction of the court that was engaged, in addition to the types of claim of reckless lending not amounting to valid legal claims. Another example of a legally unsound claim was one in Hurley versus Pepper Finance Corporation Ireland DAC of 2022. That case concerned a claim by a borrower who was alleging that the loan at issue attracted protections under the Consumer Protection Code and the 1995 Act. However, it was clear from the statute that a housing loan did not attract the protections that the borrower was claiming It did. So because the type of claim was largely based on documents, loan facilities, mortgages, and reference to statutory law, the court at early stage was able to confirm that there was no basis to the claim. Essentially, the court determined that because the loan facility at issue was a housing loan, which was clear from the text of the various documents, the plaintiff simply couldn't get the benefit of the protections that he said he had. It simply wasn't statable. And Judge Allen stated that if the statement of claim discloses an arguable question of law, the true test is whether the argument has a reasonable prospect of success. The onus is not on the plaintiff to demonstrate that he has a reasonable prospect of success, but on the defendant. So that's a burden of proof. And then ultimately, the Judge Allen concluded that there was no reasonable prospect of success because simply the loan at issue was a housing loan, and so the protections didn't apply. Another example of a case with no legal basis is TB and the HSE and An Garda Síochána and Novartis of 2022. That was a medical negligence claim, and a key point in that claim was that, contrary to legal and procedural requirement, the plaintiff failed to obtain an expert report. So whether it's a medical negligence claim, any type of professional negligence claim, a plaintiff is obliged to get an expert report to confirm that there is liability, professional negligence liability on the part of the professional. The plaintiff here failed to do that despite being put on notice of that requirement. And in those circumstances, the court was satisfied to strike out the proceedings. In the absence of an expert report, that was a valid basis. So that the second category there is res judicata. An example of that resulting in a strikeout is Behan versus the Governor and Company of Bank of Ireland of 2022 in the Supreme Court. That case concerned a summons that was issued in 1990 as against Bank of Ireland, which related to a reduced interest scheme for farmers in severe financial distress. That case was heard and determined, and then the same litigant purported to bring the same claim again in 2001, and having noted that the claim was the second one of its kind, it's already been determined on its merits, the court struck out the proceedings. And you'll see Denham, Ms. Justice Denham stated that the High Court erred in determining that the matter was not res judicata. The issue of the scheme was litigated previous by the parties. Further, the consequences for the applicant were the same, whether being considered under the allegation of negligence or fraud. The damages were the same. And in addition to res judicata, practitioners should also be aware of the rule in Henderson versus Henderson, which is a slightly lesser rule or less strict type of rule where the court has more flexibility, and it prohibits a party from bringing a later claim that should have or could have been brought in an earlier claim. It's along the same lines of res judicata, but there is a bit more leeway and argument and discretion on the part of the court. That a claim is statute barred, that might result in proceedings being struck out from the get-go. A recent example is Cunniff versus Cunniff of 2022 in the Court of Appeal, Mr. Justice Allen. It was a probate matter. He was considering an application under Order 19, Rule 28. And he observed the purpose of the statute of limitations. It's a legislative policy to prevent litigation of stale claims. And in the circumstances where the death of the party's father occurred nearly 30 years previously, and the action commenced in 2016, the appeal was dismissed under the statute of limitations. And practitioners should bear in mind the usual limitation periods: 2 years for personal injuries, 3 years in medical negligence, 6 years for tort and contract, and then a 12-year limitation in general for debt secured on land, so mortgages or securities. And then practitioners should also be aware of provisions in the Statute of Limitations Act, which allows for a fresh accrual of action. But in any event, it's a matter to be assessed based on the facts of each particular case, in line with the statutory provisions and time periods in the statute of limitations. So the fourth category ties in with the phrases vexatious and frivolous, and really that boils down to the facts of each particular case. The case of Ewing versus Ireland from 2013 Supreme Court decision identified 6 general criteria to bear in mind in determining whether a claim is frivolous, vexatious. And an indicator, the first indicator that the court noted was the bringing of one or more actions to determine issues which have already been determined by a court of competent jurisdiction. Secondly, cases where it is obvious that the action cannot succeed. Third, cases where no reasonable person could expect to obtain relief. Fourth, where the action is brought for an improper purpose. And again, that would be for the defendant to show on affidavit, and that would trigger the inherent jurisdiction of the court. Fifth, where the person instituting proceedings have failed to pay the cause of unsuccessful proceedings. And sixth, issues rolled forward into subsequent actions, repeated and supplemental. So you will often find it's fairly common in courts that certain litigants bring a plethora of cases along the same lines. You're kind of veering into Isaac Wonder type orders where the court can have jurisdiction to prevent a litigant from bringing multiple claims, but that is a factor that the courts will take into account in determining whether a particular set of proceedings are frivolous and vexatious. A recent line of case law of that type of litigant bringing hopeless types of cases can be seen in the recent decision of Toy and Toy versus the Government of Ireland and others, 2022 in the High Court. It was a decision of Justice Dignam, and it followed a line of case law that where litigants were essentially copying and pasting the same type of claim. And I had one myself a couple of weeks ago, which I'm waiting judgment on. But what the plaintiffs are claiming in it is that in unrelated proceedings which concerned state parties, because let's say a chief state solicitor or a state party didn't comply with a court order, these types of claims are claiming that because in those particular set of proceedings which are unrelated, because there was no reprimand for the state, well then the plaintiff in the instant set of proceedings are immune from summons. That seems to be a common claim or allegation from plaintiffs. They seem to argue that there's a constitutional crisis. Now the courts in a number of decisions, including a decision of Ms. Justice Butler, have determined that it's not a valid claim. Judge Dignam kind of summarized the position, saying that, in my view, the asserted facts simply do not and cannot give rise to the inference and legal conclusions upon which the plaintiff's claim is based. Even if the Minister for Justice and the Attorney General failed to enter an appearance in an individual case and the case was struck out, and the DPP failed to comply with an order in another individual case, it does not and cannot follow that the Minister, the Attorney General, or the DPP are immune to summons and orders respectively. So Judge Dignam concluded that none of the issues can be addressed by an amendment of the pleadings or by interlocutory steps, such as the raising of interrogatories or discovery, and so the case was struck out. So you'll see there that even if a plaintiff's case is hopeless from the outset, the court will engage in an analysis to determine whether the pleadings or the case could be saved by an amendment. And if they could, the likely outcome is that the court, rather than striking out the proceedings, would give the plaintiff a further opportunity to amend the claim to make it a valid claim. So just in terms of conclusion, I won't keep you any longer. I note that we're over the 30 minutes. So just by way of concluding remarks, you'll see that the courts are amenable to strikeout proceedings. They can do so under Order 19 Rule 28 of the rules of the Superior Courts, where you're looking to see whether there is no reasonable cause of action, it's frivolous and vexatious. They're the key words. The court also has the power under the inherent jurisdiction. There you're looking again to frivolous, vexation, bound to fail, abusive process. And when you have those words in mind, you're kind of looking at the facts. Each case depends on the facts of each particular case. The four categories, the four primary, it's not exhaustive. You're looking to see if there's no legal basis for the plaintiff's claim. You're looking to see if the claim has already been dealt with. Is it res judicata? Is the Henderson versus Henderson prohibiting rule invoked? Third category, is the claim statute barred that could allow you to go in and look to have the proceedings struck out from the outset? And then you're looking to see, is the case futile, misconceived, hopeless, irremediable? Is there a long line of similar type of cases which essentially amount to an abusive process? You'll see that a common defense to these types of motion is for the plaintiff to counter motion, looking to amend or save the pleadings. And if there is a possibility that they can be saved, the court is very likely to grant the plaintiff that relief, albeit that there may be cost implications against the plaintiff for it. Further final remarks that the court is likely to facilitate the amendment. And then finally, one matter to bear in mind for practitioners is the issue of costs. So I think it's wise at the earliest possible stage to consider if it is a claim amenable to strike out. And if you get the case struck out as early as possible, well, that's great from a cost perspective. If you leave it longer or further down the line, there may be implications from a costs point of view, particularly in light of the new cost regime, where the court has more of a flexibility and an obligation to consider matters on the round rather than just winner takes all sort of scenario, which previously had been the case. So it's more codified and there are more considerations to take into account, and the court has more discretion in light of the new statutory regime to make tailored cost orders. So that concludes the slides. I hope that you've taken something from that. I'm happy to take any questions if anyone has any questions.
Anybody got any questions for Ed? I've got nothing in the chat room at all.
Very good. Well, thank you very much for having me, and I hope people have taken something from that. I'm happy to address any questions if anyone has any questions after the call.
Thank you. Thanks, Ed.
Thanks very much, Ed.
Will you send your slides over to me?
I will indeed.
We can include them in whatever we put on the website.
Very good. Thank you very much, Lawrence. Thank you, Rachel.
Okay.
Thank you, Edward.
Okay. Thanks, everybody. I'll close the session now then, unless there's anything else. Okay. Thanks, everybody.
Thank you.
Thank
Thanks a
you.
lot.
Thank you. Thanks. Thanks.